Imagine a process meant to reform laws, but instead it ends up building and entrenching an entire industry. This is the concern raised about the Australian Law Reform Commission's recent surrogacy inquiry. When those who stand to benefit from an industry are the very experts shaping its regulations, neutrality is lost. Instead of asking whether surrogacy should exist, the process focuses on how best to implement and expand it. This shift transforms law reform into stakeholder-driven policy construction, where the interests of industry insiders take center stage. In this video, we'll explore how the ALRC's surrogacy inquiry illustrates this troubling trend, why it matters, and what's at stake for vulnerable women and children. A genuine law reform inquiry should always meet three basic tests. First, it must ask whether the practice in question should exist at all. Second, it should give equal weight to evidence of both harm and benefit. Third, it must avoid structural conflicts of interest among its advisors. The ALRC's surrogacy inquiry, however, fails all three. The Commission was not even asked to consider whether surrogacy should be permitted or banned, meaning the outcome was predetermined. The focus shifted from evaluating the practice to simply optimizing its implementation. This approach closes the door on meaningful debate and ignores the foundational question: is surrogacy itself justifiable? Let's look at who's actually shaping the surrogacy policy. The ALRC's advisory committee is largely composed of lawyers and clinical professionals whose careers revolve around surrogacy. Out of 11 members, at least 6 are directly involved in facilitating surrogacy arrangements. Their professional interests align with expanding and regulating the industry, not questioning its existence. The rest are judges or professors specializing in family and human rights law, but none are positioned to critically evaluate the harms of surrogacy. This isn't a panel set up to scrutinize risks or ethical concerns. It's a group assembled to design and entrench a regulatory system. When decision-makers are financially invested in the industry's growth, can we really expect impartial law reform? The ALRC's proposals go far beyond harm reduction. They actively build a national surrogacy industry. Proposals include establishing a national regulator, creating support organizations, expanding recruitment and supply, normalizing financial payments, and even altering birth certificates to erase gestational mothers. These measures construct recruitment pipelines, payment mechanisms, and legal frameworks that make surrogacy a permanent fixture. Crucially, this system building happens without proportional engagement with the documented harms of surrogacy. International human rights obligations are sidelined, and the voices of those harmed are minimized. Instead of protecting the vulnerable, the process enables industry expansion under the guise of reform. Despite extensive evidence of harm, ranging from maternal deaths and trafficking to child abandonment and abuse, the ALRC's discussion paper systematically minimizes these realities. Surrogacy is often marketed as a generous, selfless act, but behind the scenes it's a global industry rife with exploitation. Cases of women being trafficked, children sold or abandoned, and surrogates suffering medical harm are well documented internationally. Yet these harms are not meaningfully addressed in the inquiry. When a process moves straight to building systems while sidelining such evidence, it's not neutral law reform. It's policy built for profit, not for justice or protection of the vulnerable. Law reform should test power, protect the vulnerable, and restrain harmful practices, not optimize them for industry growth. When institutions propose frameworks that expand and entrench an industry while drawing expertise from those who profit from it, the result is not principled reform. In the case of surrogacy, this means building a national system that places women and children at risk, ignores evidence of harm, and forecloses abolition as a legitimate outcome. True justice-centered lawmaking demands impartiality and a willingness to confront uncomfortable truths. Anything less is policy built around profit, dressed in the language of reform.